you're on something.
Yes,
You're on something right now. What are you on?
Probably a little bit of cocaine.
Probably a bit of cocaine.
Welcome to Bench Report Court Cam.
Court does call the cases of the people versus Quincy Jones.
Okay, Richard McDuffie for the people.
Morning, Your Honor. Mike Getty, Assistant Public Defender on behalf of Mr. Jones, who's here to my right, Judge. State your name, Mr. Jones.
Quincy Jones.
You feel better today?
Yes, I do.
Do you?
Yes.
Sobriety's a funny thing, isn't it? Never mind. You don't have to answer that. I'll never show up here like that again. You hear me?
Yeah.
All right. What are we doing?
Yeah. Oh, I'm sorry.
Oh, I'm sorry. This was also an arraignment. The court was attempting to arraign him on the new case last time.
Right.
Yes, on the 25 F2 1293, Your Honor, or 0697, Your Honor, anticipating that will be appointed, I would waive reading and standing.
All right. Defendant having waived former reading standing mute, court will enter a not guilty plea as to that case. And the public defender is appointed in that matter. What date did you want me to set probable cause?
Your Honor, I did receive the police report earlier this morning. Ms. McDuffie was kind enough to send it to me. The version I got last night wouldn't open, so I haven't had a chance to go over that with Mr. Jones. I'd ask for the next available date, and if I could be heard on bond.
Yes.
Your Honor, Mr. Jones is here.
Well, hold on a second.
Oh,
I'll make it the 17th, so he's not.
Thank you, Judge.
June 17th, 2025 at 9. That's time on the other matter too. Go ahead.
Thank you, Judge. Mr. Jones is here in custody today, obviously. He does have a place to reside. He resides in Ann Arbor. He does have his own apartment. He does receive assistance from Avalon Housing. I was able to reach them on the phone, and they are, would continue to provide him assistance in navigating the ins and outs of life. He would comply with whatever drug testing the court would require, where sober link if the court, or a scram tether if the court required such. He does receive a monthly, I believe, does receive a monthly shot under an ATO. I'd ask the court to give him an opportunity to have a personal recognizance bond in this matter with monitoring and whatever testing required.
The defendant walks into Judge Simpson's courtroom, but within seconds, something feels off. His eyes are unfocused, his movements are jittery, and his speech barely makes sense. Judge Simpson asks a simple question, but the man rambles, contradicts himself, and starts mumbling nonsense. The courtroom grows quiet as everyone realizes this is not normal nervous behavior. Judge Simpson leans forward, clearly concerned and irritated, asking the defendant understands where he is. The answer only makes things worse.
That the court deems suitable.
From the people.
Your Honor, well, I don't have an issue. My original request was for a $7,500 PR bond on this case. It probably goes without saying, especially at this point, that I am requesting a testing order. I don't know to what extent alcohol is something that Mr. Jones deals with, but certainly drugs, narcotics, cocaine specifically, are of concern to the people. I think that there was a request on his older file, but because he had been hospitalized and gotten out of treatment, the court declined to impose a testing order at that time. Unfortunately, I think we see that we probably need to keep close tabs on Mr. Jones's compliance. Other than that, no objection to the PR and the standard.
Yes. How often are you using when you're out?
Well, but I am banging not that much.
Why?
Banging not that much.
Because I was a bit surprised you did what you did last week. No, usually you show up and you show up sober enough to take care of business.
Yeah, I had there was a lot going on between my mom's girlfriend and the house selling. It's
All right.
Yep. Yeah.
On case ending in 575. In that case, that I've adjourned to the 17th at 9, I'm going to reinstate his previous bond of the 5,000 personal recognizance. All right, and the previous conditions. It means that you're going to have testing on that. Understood?
Yes, sir. Yes, Your Honor.
On his new matter, I'll set his bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons. There's to be no use of alcohol, recreational marijuana, or any illegal drug. You need to repeat that?
Oh, yeah.
Sure.
Yes.
I'm going to order that he test at community corrections. How often are you testing under the old order? How many times were they calling you?
Not once.
I don't believe he was
When was it?
at all.
Oh, that's right. So I'm going to order intermediate supervision.
Judge Simpson warns the defendant to speak clearly and behave appropriately. Instead, the man interrupts, laughs at the wrong moments, and begins arguing with the judge in a confused, aggressive tone. The judge asks point blank if he's under the influence of drugs or alcohol. The defendant dodges the question, which only fuels the tension. Judge Simpson's voice sharpens as he reminds him that court is not a joke, and that showing up like this is a serious violation.
With at least 2 times per week drug testing. Got that?
Okay.
Thank you.
Your Honor, will he need to report immediately to community corrections if he gets out or within 24 hours? Or will they come see him before?
Yes, they get him out, community, and you're out before 4:30. I want you getting over, or 4 o'clock. I want you getting over there to community corrections.
Yes, Your Honor.
You hear me?
Yes, Your Honor.
Thank you, Your Honor.
All right. Got it. Court does call the cases of the people versus Quincy Jones.
APA Rachel McDuffie for the people.
Camera Dadish on behalf of Mr. Quincy Jones, who is approaching. Can you put it on the record?
Quincy Jones.
All right, he has a new case, you know that.
Yes, Your Honor.
All right. So, Mr. Jones, you have a new case currently, okay? And you're before the court on a complaint that alleges that on or about March 14, 2025, at the location of South Huron in Michigan Avenue in Ypsilanti City, that you did knowingly and intentionally possess less than 25 grams of a mixture containing cocaine. Do you understand that charge? I'm not saying whether or not you did it. I'm saying, do you understand what you're charged with?
Okay.
Do you?
I understand that.
All right. That is a felony punishable by up to 4 years incarceration, $25,000 fine plus court costs. You understand that? Mr. Jones, let me ask you something. If I had you tested right now, you going to test clean?
For what?
Mr. Allen. Mr. Jones, what's going to be in your system? Because I can't arraign you if you're under the influence of something. So you might as well just tell me.
Some marijuana.
And what else?
Probably a little bit of cocaine.
Probably a bit of cocaine. When did you take that?
Be truthful with you.
Huh?
Yeah, I'm be truthful with you.
Okay. So when did you take the cocaine?
About 2 or 3 days ago. So it ain't on my system.
Seriously?
Yeah.
So when's the last time you had any marijuana? You're on something.
Yes,
you're on something right now. What are you on?
What do you mean? Like,
The worst thing is to lie to me.
what do you mean? What do you mean like, on something? Like, what do you mean? Like, did I do something to get today or?
I don't think that's a really hard question.
Oh, I smoked some marijuana last night.
Tell you what, it's real clear to me that you're on something. I'm not going to arraign you on new charges. I'm not going to do anything with these other charges. I'm adjourning all of this over to next week. But right now, on your one case, your bonds revoked, defendants remain.
Thank you, Your Honor. I answer approach.
Why?
You can wait till.
Good. That works. And I'm gonna set that for the, yeah.
Thanks for watching. Stick around longer and click the highlighted videos to your right. See you there.
The defendant starts talking over everyone, making bizarre claims and refusing to follow instructions. He sways, scratches uncontrollably, and can't stand still. Judge Simpson bangs a gavel, demanding order. The judge makes it crystal clear. This behavior is unacceptable and disrespectful to court. Deputies begin to shift closer as the defendant continues spiraling. The courtroom realizes this is about to end.